The party's National Communications Officer, Sammy Gyamfi, has joined me on the line to help us appreciate the party's position on this matter. Hello, good evening, sir. Welcome to Eyewitness News. Why do you describe the Attorney General's advice to the Auditor General as unconstitutional?
Thank you very much. The Office of the Auditor General is the creation of the supreme law of the land, the 1992 Constitution, which governs the work of that office. And the Constitution is very, very clear at Article 187, Clause 7, that the Auditor General is independent and not subject to the direction or control of any person or authority. And therefore, the attempt by the Attorney General, Godred Dame, to direct the Auditor General on how he should do his work is clearly unconstitutional and unacceptable. The Auditor General, under the Audit Service Act of 2005-84, is given powers to conduct special audits, such as was conducted into COVID-19 expenditures by the Auditor General. And Section 23 of that law, the Audit Service Act of 2000, Act 584, enjoins the Auditor General to publish audit reports immediately he submits them to Parliament. And so what the Auditor General has done by publishing the special audit report on government's COVID-19 expenditures is in strict conformity with the law. In fact, that is what he is mandated by law to do, and that is what he has done. And so it is totally irresponsible for the Attorney General, who should know better, to be telling the Auditor General that he shouldn't obey the law. He should not do what the law of this country mandates him to do, but rather do what he, the Attorney General, sees fit. Is the Attorney General saying that he's not aware of Section 23 of the Audit Service Act that enjoins the Auditor General to publish audit reports?
Indeed, he says he makes this comment, recognizing or knowing fully well that there's a provision, as in Section 23 of the Act 584. But before that, what he is telling the Auditor General is a piece of advice. He said, I advise a withdrawal of the report. So I'm not sure that will be same as control or direction. He's advising him on the basis of an argument to withdraw the publication. The Attorney General of Ghana is the principal legal advisor to the government of Ghana. Mm-hmm. The Auditor General is not part of the government of Ghana. And so he does not need the advice of the Attorney General. That is an ungodly intrusion into the mandate of the Auditor General. The Auditor General is not subject to his advice. And as I've said, it is irresponsible for the Attorney General to be given an advice which is expressly against the laws of this country. Section 23 of the Audit Service Act is clear. And as you have indicated, he acknowledges that in his letter, that he is mindful of Section 23, that imposes a duty on the Auditor General to publish that audit report. So, where from this so-called advice? He makes the point. He makes the point in terms of Section 23 that we have Section 23 here, and we have Article 187 as well. These two, provisions of the law appear to be saying two different things, which in actual fact must be complementary to each other. He says that I'm mindful of the provision of Section 23 of Act 584, which seems to mandate the publication of the reports as soon as they have been presented to the Speaker to be laid before Parliament. However, the laws governing the functions of the Auditor General ought to be construed as a whole. And it says that the constitutional duty of the Auditor General to submit his reports to Parliament and Parliament's consequential obligation to debate and scrutinize same will be grossly prejudiced by a prior publication of the report. It means that Parliament will have to consider the report But if you publish it to the reading of everybody before Parliament considers that report, that is prejudicial to the people who might have been named
in other words,
in the
you're
report.
saying that, So in other words, what the Attorney General is saying, and I don't know whether you agree with him or not, but what he's saying is that Section 23 of the Audit Service Act is unconstitutional.
Not necessarily, but you need to look at the intent of the law, the purpose of the law.
What intent of the law? The Auditor-General is not bound by Godred Dame's construction of the law. He is not bound by, because this interpretation of the law is, with all due respect to the Attorney General, very flawed. Because there is nothing in Article 187 of the 1982 Constitution that contradicts Section 23 of the Audit Service Act. Article 187 of the Constitution doesn't say that the Auditor-General, after he has conducted an audit and put together a report, must wait for Parliament to consider the report before he publishes it. It is not there. Article 187 of the 1982 Constitution, when the Auditor-General completes an audit and prepares a report, his work is done. His report is not affected by anything Parliament does. Article 186 of the Constitution says that report should be submitted to Parliament for debate, not consideration, for debate. And when necessary, Parliament may, through a committee, address or deal with matters arising from that report. So Parliament is given a duty under the Constitution to deal with matters arising out of the Auditor-General report where it deems it necessary and in the public interest. But the Auditor-General is given a separate mandate to audit and prepare a report, and a statute has given him a duty to publish that report immediately after he submits the report to Parliament. Where is the contradiction? What is so difficult about this that Godred Dame cannot understand? In any case, let's even examine this so-called construction of the law he's urging on the Auditor-General. If or when a report is laid before Parliament, what happens to that report? The report automatically becomes a public document, unless it is marked as confidential or secret document. And in this country, since the inception of this Fourth Republic, any time the Auditor-General has laid before Parliament his reports, those reports are deemed as public documents. What that means is that any member of the public can access that report from the table office of Parliament or the Public Affairs Office of Parliament, or through their members of Parliament who are giving copies of these public reports. And so what he is saying is much ado about nothing. If the Auditor-General doesn't even publish the report on his website, as he is enjoined to do by Section 23 of the Audit Service Act, by laying it before Parliament, the document becomes published. It becomes a public document, and any member of the society, including media men, can access it and publish it. Doesn't he know this basic fact? And so what we are saying is that it is not Godred Dame does not have any right to advise the Auditor-General. If he thinks that there is any law in our statutes which is unconstitutional, he can lay before Parliament an act to amend the law or to repeal the law. Until that is done, the law is the law. And the Auditor-General cannot be working, with the individual or personal opinion or interpretation of the Attorney-General. He can only work with what is written in the law, black and white. And again, let me also make the point that there is nothing prejudicial about the publication of an audit report. Let's get that straight. You can only make the point that the publication of audit reports by the Auditor-General is prejudicial to the interest of auditees if such auditees are not given a hearing during the audit. But we know the standard procedure that the Auditor-General uses for his work. All auditees are given a hearing in line with the auditory pattern rule by the Auditor-General, and their responses are summarized and captured in this report. And the COVID-19 Special Audit Report is no exception. When you read all the findings and recommendations of the Auditor-General, you would realize that the responses of the auditees have been summarized and captured. And so publishing that report is not in any way prejudicial to the interest of auditees who might have been indicted in the report. In any case, the Auditor-General's office is a public office. When the Auditor-General uses public funds to conduct an audit and prepares a report on that audit, that report is a public document. And therefore, Godred Dame cannot be advising or directing the Auditor-General of Ghana not to be publishing such public reports or public documents. And so we believe that the Auditor-General should be commended for doing what he is required to do under the laws of this country and not condemned as the Attorney-General has sought to do. And we think that the Attorney-General must immediately withdraw the letter that he has sent you, because the letter has no basis in law. It has no legs to stand on. The Attorney-General has no authority or right to even purport to advise the Auditor-General. That is clearly unconstitutional. And all of us as Ghanaians should be worried about, this latest development, because we know how the former Auditor-General, Yao Domelevo, was hounded out of office by this corrupt Akuamoah-Asiedu government. Because he began to expose the corrupt activities of elements in this government. This is how it normally starts. And when we turn a blind eye to it and we encourage it, then they begin to do it with impunity.
I see. So you are calling for a withdrawal of the Attorney General's letter to the Auditor General. In the absence of that, of course, now he is written to the Auditor General. What should the Auditor General do with this letter?
So we've called on the Auditor General to totally disregard the letter from the Attorney General, as saying is unconstitutional, despicable, and totally distasteful. We should not be encouraging such acts from the Auditor General, who is a leader of the bar and should know better. And we expect the Attorney General to acknowledge the fact that he has booked big time. And do the needful by withdrawing that letter.
Very well.
And we are also calling on the media and civil society organizations and other well-meaning Ghanaians to condemn this ungodly intrusion and interference in the work of the Auditor General by the Attorney General.